clarification, I think the bio was actually the other Vanessa, Vanessa Hale, not Vanessa Bailey. So, so just to clarify, I'm Vanessa Bailey. I'm from Intel Corporation in Washington, D.C., where I'm the Senior IP Policy Counsel for Intel Corporation, handling all of the patents, trade secrets, copyright policy. So just to clarify, I think that was a different bio. But nonetheless, thank you all for hanging in there. I realize this is your Saturday. You just had lunch. It's like the next to the last panel, and we're between you and your weekend. So thank you very much for hanging in there with us. So today I wanted to talk about basically the interplay between remedies, namely injunctions, and innovation. And as we all know, with the advent of high-tech products, with your smartphones and all the thousands of patents that are involved in that, that you have to be very mindful of remedies when you're talking about remedies on multi-component products. And with this, judges are basically gatekeepers of this and must promote strong but balanced IP to encourage innovation. I think it was yesterday even that one of the panelists was speaking about, or posed the issue or question of what happens in India when you have an interim injunction. And, you know, in the Indian court system, 9 to 10 years pass or whatever the time frame is, and it comes to pass that either the patent was invalid or the patent was not infringed or both. What really happens to that, and what does this do to impact, say, that company, especially if it's a small company, especially considering how technology advances so quickly and rapidly that this probably does do very much harm to the company and put the company out of business. And this is not the right presentation. You know what? Let me see if I can. This was not the right one. Hold on. No. Can someone help me out here? This wasn't the one we just looked at.
1 second.
Sorry about this. Well, I'll just speak while he pulls it up.
Which one is your slide?
That's it. Yes.
Right.
That is it. Correct. Can you make it so that it goes into the? Okay. Sorry about that. Okay. So basically, I was showing a kind of infographic of our patent systems share the common roots between the U.S. and India. First, we look at 500 AD, BC, sorry, in Greece, exclusive rights for 1 year for the winner of a culinary competition. In England, early England, first patent granted by King Edward III. 1421, Florence, Italy, the first patent awarded for a marble carrying barge. 1474, the first patent statute grants patents for any new and ingenious device not previously made. We have 1790 in USA, first U.S. Patent Act adopted, first U.S. patent awarded for a process for making potash. The Act, I guess we might call it 6 of 1856 in India, first legislation relating to patents. In 1877, Germany, first unified German Patent Act adopted. So the difference here is that early products practiced only a few patents, making the product essentially equal to the patent. So there was a strong correlation between the actual product and the patent. So this is back, of course, showing the example of Thomas Edison's electric lamp being the electric light bulb, of course. But today's high-tech products are different. They practice many patents, as we all know here, a lot of different functionalities in a single device. And so this is where we come into issues, I think, when we're considering remedies and for innovation. High-tech products require more careful approach to damages. As you can see, taking the example of a laptop, thousands of technologies and over 300 industry standards in a single laptop. But of course, in these products, there are both patented and unpatented technologies. A single patent may only be a small part of a product value, and in fact, most of the time, this is the actual case, especially when you come to litigation. Standards exist solely to encourage widespread use of standardized technology by all willing licensees, but yet we do have the instance where some SEP owners seek injunctions in pursuit of greater than FRAND royalties. Such high-tech products require us to more carefully consider when injunctions are appropriate. Looking at, say, the pie and the business value of the patented technology, I think the real issue comes in on injunctions, for us at least. You're looking at injunctions, what does that do? It takes basically 100% of all profit because you take the product off the market. So this is an issue that must be looked at and considered. But our judges play a critical role in achieving the objectives of our patent systems. Judicial decisions on what remedies are appropriate in patent cases are central to the objective of maximizing innovation. In making such decisions, it is critical to consider the concept of proportionality. I don't know if you could see the slide that came by kind of quickly there. It had the Vernetics case, which of course is the U.S. case on proportionality, or a U.S. case on proportionality, whereby it stated this, but people now in the U.S. kind of have a lot of jargon and things they say, which people say SSPPU, which is Small Saleable Patent Practicing Unit, is a multi-component product containing several non-infringing features with no relation to the patented features. The patentee must do more to establish what portion of the value of that product is attributable to the patented technology. And there are even more recent cases that teach us that some sort of apportionment, obviously, to weed out the unpatented for the patented features. To maximize innovation, judges must be empowered to consider whether injunctions are proportional remedies. Well-defined standard to determine when injunctions, including permanent injunctions, are proper should consider proportionality concepts, meaning concepts of compensation only for the technology and patent at issue. As quoted by Lord Justice Jacob in the Virgin Atlantic UK case, an injunction under UK law is always a discretionary remedy. The remedy to be granted should be proportionate. That's not to say injunctions are not appropriate sometimes. Our injunctions are an appropriate remedy in some cases, but not in every case, of course. Injunctions may be proper when a product manufacturer has a history of not licensing or when a patent is very significant. But injunctions are not proper when sought merely to extract an unwarranted share of a product's value by threatening full market exclusion. And one example I was talking about, I guess, yesterday in one of the panels was the kind of phenomena of, people have different names for it, some people call this patent trolls. And the concept of a person who really didn't contribute much to the standards, did not contribute much, if anything, frankly, to innovation, doing what is legal, which is buying a patent and asserting them against people who use the patent, who implement the patent. And this is a concept I was trying to think about yesterday, which is, you know, you've got to be mindful that even if the system works today and it's not being kind of abused today, who's to say that it won't be abused in the future? So you have to be mindful of this concept of the patent trolls that are inevitably going to come to India if they're not here yet. With regard to injunctions, I point to the EU and US use of a safe harbor type of approach for willing licensees, looking at the Huawei ZTE case and the US Federal Trade Commission, MMI, Google consent decree. So this is just a case looking at injunctions and how detrimental they could be to innovation with regard especially to small and medium enterprises. This is actually not a standards case, but it's just an example I wanted to show because I know people involved in this case. It was not me, though, obviously. The Ampledata is a Belgium DDS startup company who opened up in the US from Belgium, obviously. But 7 months later, they were actually sued, claiming that they infringed 4 of the patents. The patents were basically the lifeline of the company, and with they failed on the patents, if they were found to be infringed, the company would definitely have gone under. the patent holder sought an injunction, permanent injunction, to block the Amplidata system from the U.S. market. Essentially, after I think it was like 3 years of litigation, Amplidata did prevail, and they knocked out the patents at issue. And I think there was a stipulation that they did not infringe any of the patents in suit. The case is currently pending on appeal, obviously, but following the successful resolution of the district court case, Western Digital Technologies, a well-known, at least U.S. company, did purchase Amplidata. So that is just, I wanted to show an example of what is at stake here, especially when it comes to small companies, and how it has an impact on innovation. Another, I guess, example is the Vlingo case. I don't know if you know this one. I think it was Vlingo and Nuance. Nuance being, I guess, the technology behind Siri and Apple phones. And in that case, I think Vlingo went to litigation for many years. At the end, prevailed, but they actually just went out of business due to the litigation costs and were actually purchased by Nuance. Like with injunctions, damages should embrace proportionality concepts. We must carefully separate the value contributed by the patent from the value contributed by other things, meaning non-patented items, value attributed to the standard, and things that are not attributable to the patent itself. Failure to do so gives patent holders an unjustified and disproportionate windfall. This harms innovation by allowing a patent holder to capture value created by others. So in conclusion, I wanted to say that judges are the main gatekeeper here. Judges can maximize innovation by ensuring strong and balanced remedies. Courts should be empowered to decide when injunctions are proper under a clear standard that considers proportionality concepts. Courts must ensure damages fairly reward a patent owner for the value he created, but not for the value that he did not. So thank you.